Okay, now we have a last journey about our assignment. We'll have seen what it should not be saying it's usual in experience. So we now the concern of federal state statutes and regulations. So click on that section. Then what? Let us finish with the Japanese case. Perhaps story in long history. How do you know one case decided in 1918? It's from state of Washington, and probably we have some basics about that last class. It involves a Treaty of United States concluded with Japan in 1921, Asakura. I will have another case, Korematsu. Two cases are distinct in U.S. jurisprudence. One is on the issue which raises the constitutional question. Actually, Japan is an enemy state in the World War II. Asakura case was decided in 1920s. In the period, Japan practiced imperialism in East Asia, and all Korean people are subject. So, Korea was immersed in the imperialist clan of Japan, and was ruled by Japanese emperor. And they would have ties and establishment with United States in period of time. And the case involves the controversy about city ordinance enacted by the state of Washington. So let us type Asakura. Then what is the result on our vision? As I've introduced, the state code from Washington. The citation would be what? Reverend Code Washington, ARCW, and a regulation by political divisions. The regulation of pawnbrokers and second-hand dealers under this chapter is not intended to restrict political subdivisions from enacting ordinances or codes requiring the licensing of pawnbrokers, second-hand dealers from enacting ordinances or codes which are more restrictive than the provisions of this chapter. So the case related with this statute, state statute, would be listed to facilitate your research. Asakura versus City and Seattle. How defining useful? So this city ordinance was in controversy about true meaning of code and city ordinance, and state initiative was an authority to enact the city ordinance. So mixed context of review would be legitimate. And what is the status treaty in terms of U.S. Constitution? The treaty is one source of federal laws in which federal supremacy would operate. So may legitimately preempt any contradictory words or provisions of state laws, city ordinances, and others. The treaty between the United States and the Empire of Japan stated citizens of each country enjoy the right to carry on a trade or business within the other country. Plaintiff in error were Japanese subjects who lived in the United States and operated pawnbroker business. Plaintiff in error challenged the city ordinance that prohibited aliens from engaging in pawnbroker business, arguing the ordinance violated the treaty. The Supreme Court of Washington upheld the city ordinance, and it was disputed in federal review. Well, actually, certiorari was granted, and Supreme Court would find contrary. Actually, the treaty is a federal source of law, and the treaty-making procedure was clearly set forth in the Constitution. And what actually who initiate the negotiation? And plenary representative or ambassador of the United States who negotiate, perhaps with delegation, not this. And the treaty would be signed by President. The Senate would be a listed authority to approve with this treaty, and that is the same with the Korean Constitution. National Assembly has some authority about a treaty conclusion. They'll put approval in the strict formality of resolutions. What a majority vote would make the treaty approved, eventually concluded with the attachment of presidential signature, I suppose. And the bicameralism would be distinct. The House would know or say about foreign relations, oftentimes, generally. And that is the case in the United States. Nonetheless, the House would have exclusive power to initiate bills, which raises a revenue. So the House is principally responsible in terms of purse power. So actually, a budget and finance would be controlled by the initiative House. So the power to initiate the bills on that context would not be vested in the Senate. So bicameralism would often require collaboration of both units. So we consider the process in the kind of joint session, and the steps to be circulated through both chambers of Congress, and in some cases a serious referral to the review, among another, and consultation, committees and subcommittee process would provide a layer of review, perhaps serves the need of prudence in creating public policy. nonetheless could be poised in balance between both chambers in general theory of constitution. So foreign and domestic dimension would come as a matter in that government. So you see the musical points raised by counsel. The point of contention would be examined by the court and might be answered as a response. I have stated the operation of facts and law in the judicial proceeding. How do you consider the role of trial court judges? Their role would be vested on fact determination, so principal responsibility from trial court. The legal argument would be relevant with even Supreme Court review, and the law falls within the responsibility of court. So the counsel's argument would not be determinative in the status of applicable law. Nonetheless, the facts or related argument should be raised clearly, principally in the proceeding of civil action. That is the responsibility of counsel. And the ordinance would raise the interpretive doubt. Let us take some words from counsel. It has been held in numerous cases that if the business is one that may be prohibited, aliens may justify the denial of privilege. Of course, the state cannot discriminate between aliens and citizens in respect to those useful businesses which every person may follow as a right. The basis of classification between aliens and citizens being a proper one, the ordinance is not valid because Congress has so far failed to make Japanese subject to naturalization. So Justice Butler delivered the court opinion in this case. A treaty made under the authority of the United States shall be the supreme law of the land. The judges in every state shall be bound thereby, and anything in the constitutional laws of any state to the contrary notwithstanding. The purpose of the ordinance complained of is to regulate, not to prohibit the business of pawnbroker. But it makes it impossible for aliens to carry on the business. It need not be considered whether the state, if it sees fit, may forbid and destroy the business generally. Such a law would apply equally to aliens and citizens, and no question of conflict with a treaty would arise. The grievance here is the plaintiff in error, in violation of treaty, is denied equal opportunity. It remains to be considered whether the business of pawnbroker is trade within the meaning of treaty. So the court illustrated precedents which might which pertains to this case. By definition contained in the ordinance, pawnbrokers are regarded as carrying on a business. A feature of it is the lending of money upon the pledge, blah, blah, blah. So the Supreme Court eventually struck down the ruling of a state Supreme Court. In this cases, the fourth tier of review had been in operation. Since the United States is federal union, in the case that the issue would involve federal interest or other issues in federalism, then the Supreme Court would intervene. And a socialist principle avenue to grant the appeal, and in that case we'll see some extraordinary measure, which is unlikely in the single system of government. Okay, this is a way to research the city ordinance. Let us take one other example. And the judicial branch will use code or regulations for the admission of lawyers in the practice of law in that state. In that case, the terms, for example, good moral character would be used. How do we define good moral character? How do you consider the past criminal history about subversive activity, or what is actually a membership of communist organization? So in that case, we consider it could be a basis to deny the petition for admission to the state bar. How do you find it legitimate? Recently, the Supreme Court has invalidated the decision of Supreme Court of California on the ground that the decision infringed with the rights to academic freedom, or the kind of liberty to beliefs and thought. And the point is that the state of California will provide a scope of public laws and a statute, and also supplemented by the regulations of Supreme Court of California. Let us type. By the way, I will point some practical distinction between public laws and state statute. How do you distinguish between two types of names? Might be used in same sense. However, in many instances, you will find the public law would encompass the scope of bills related with revenues and taxation of statute. So it is kind of initiative which spans public purse. So bicameralism would also pertain to the context. So please take care to trace the website of a state government. Then you will find two sets of I have confirmed in the state of Illinois last occasion. Consider some use of that word in subtlety of difference. In California state, has some a statute about work communism. Oh, I'm not sure. And business and professions code. That is one subject matter often found in the state research website, and many subject issues, labor unions, business and professions in general, what they call public health, agriculture, notably in Midwestern states, and some of basic judicial issues, civil evidence, civil law proceeding and evidence, or of course criminal law is an important part. Let us take this one, business and professional code. So the state government is responsible to grant a business license, and actually also administer the system of professional license and others. So qualification for applicants, it should be of good moral character. Before beginning the study of law, have done either of the following. And in the state of California, you will see some extended dealings in types about exam. For example, attorney exams will be available in some cases, and non-law school students also could be qualified to take a 645 exam upon certain conditions. And for the foreign attorneys, it set forth the requisite to sit for the bar. For example, 24 hours class in common law countries would make him eligible to take the exam. Burden of proof. Many cases involving the terms good moral character and the decision on is the state Supreme Court case. Actually, how do you discern between state cases and federal Supreme Court case? So U.S. means federal, state Supreme Court. State. So in this way, you practice to find the pertinent cases to research the interpretive issue of state regulations. So that is generally same in structure For example, the Supreme Court of Republic of Korea also has constitutional authority to enact ordinance, decree or regulation, and the subject matter interested in Korean judiciary would be prescribed. Prescription authority has been granted as a matter of constitution. I'm not sure of the case name. So my purpose is to show some ways to search for state regulations, so that will not be seriously matter. Okay, and then take another example. In that case, this state U.S. Supreme Court has overruled the decision of state Supreme Court, state of California. So his personal history is very purchasable in aspect. However, that decision is obvious to efface the constitutional command about academic freedom and freedom of expression is the First Amendment right, is what often espoused in every emphasis, and so could not override the constitutional authority, and hence was invalidated. And how do you find the proper understanding, true meaning of good moral character? We suppose two aspects could constitute a factor to be weighed: personality and also professional conscience, and fitness, character, the kind. So he should have quality to respect laws, and Constitution of the United States generally required, notwithstanding jurisdictions, often employ same terms of various states in the United States, and also he should not have such a prior record, perhaps disciplinary or criminal record, to be related moral turpitude, the kind of basis to show good moral character, and of course many virtues, professionally, personally merited to maintain the integrity of legal professions. Often good neighborhoodship, social congruence is also one factor. In over the diverse ways of interpretation, however, it should be kept essential when it involves the federal issue of federal constitution. And Korean Matthew. So it is effective. I'm not sure about the case name, Korean Matthew. just in my recollection, a slim recollection. Let's take cases. Actually, he was persecuted by government of the United States, since he's a citizen of enemy state, and federal and state case. Secondary sources, law review articles, was very effective to search for relevant sources, and case laws also get us more intimate to the specific legal question. In first place, top of this case. It was decided in 1935, during the wartime with Japan. Defendant was a native-born citizen of the United States of America of Japanese ancestry, and claimed the proclamation violated by him was void. So war proclamation might be the basis for his criminal penalty. On appeal, the court held under the Constitution of the Government of the United States in prosecuting a war, had power to do all, though necessary to the successful prosecution of a war, although the exercise of those powers temporarily infringed some of the inherent rights and liberties of individual citizens, which were recognized and guaranteed by the Constitution. The court held that the principle clearly sustained the validity of the proclamation for evacuation, which was involved in this case. So accordingly, the court affirmed the judgment of district court. So what? He was convicted. And what? Of the offense of remaining in the portion of military aid, and were placed on probation for 5 years. So considered not serious penalty. In any case, the violation is minor if it is perpetrated in peacetime, in wartime. So all persons of Japanese ancestry were not permitted to remain in the city of San Leandro, California. How do you find equal protection and other basic liberties? It's wartime, now considered most serious of a national emergency, so could be stored. The courts take that view, and often that are pervasive in practice of nation. So interesting in some cases, since it would involve some distinct aspect. Okay, how do you all find it exciting? I hope it's okay. That'll be all. Let's close my short demonstration. Thank you for your attention, and see you in next class.